Good morning, Miss Susan.
Good morning. I hope they've quit drilling in there in that bathroom. They came to fix something and I didn't know they were coming today.
Ain't that the way it always is, though?
Always.
How are you this morning?
I'm good. I'm glad it's Friday.
Indeed. Not that it makes any difference to an agent, but
Right. It just gives us some kind of feeling. I don't even know how to describe it. Just I
I
guess
concur.
because it's the weekend.
That's right. We're programmed. Weekends are your days off.
Absolutely.
It
Supposed to
sounds good
be.
whether it's true or not.
Absolutely. That's a good one. It does for sure. Oh my. But well, it is the day that we might dress down just a little bit if we don't have any appointments until,
There you
later,
go.
or you're going to walk land or something like that.
Exactly.
So I hope we have some folks join us today. It's
I can't
important, these
imagine why they
forums.
don't. Oh, I know. I learned so much from you.
Well, thank you, but I just want them all to be able to make money, and you got to know these forums to make money.
That's a fact.
Oh my word.
Well, there's plenty of people making money without the knowledge.
Well, they are. I had the vice president of First Tennessee Bank tell me back when all the foreclosures was going on, he told me that I would make a whole lot more money if I'd quit being so honest.
Oh, dear Lord.
Yes, exactly. That's basically what I said to him. I said, "What are you talking about?"
Exactly. Sorry, I'd rather not make it if I have to be
Yeah.
dishonest.
And so that's just kind of been the way I have always done it. And I want to be nice to folks and do things whatever I can to help. So
That's exactly right.
we're a few minutes early. So hopefully
Right.
some more will jump on here. Hey, I just emailed Tim. I got an email of a possible recruit for Delano, and I just forwarded it to Tim.
Excellent.
Yeah, so hopefully
She
he'll
said
see
she
that.
just forwarded something to you, Tim, a referral for a recruit. He said, awesome.
Cool. Yeah,
He's working on our TV in our lobby right now, trying to get it up and going, the computer, all that. We got it all working. Now it's just trying to make it all put together.
Is that the what Todd is got running through all the offices and such? Because
Yes,
I hadn't got that yet. So
we just got ours. So
so it is in your lobby and you're running like a commercial or something, I guess,
that's what
or
it looks like. Yeah.
cool.
There's two. There's two commercials like that runs, but it's all Weicker. I love it. I just love to have all the Weicker stuff, going.
Yeah, yeah, yeah. Somebody painted a wall down here blue, and I don't know who. And I was asking Hunter yesterday if he was in the mood to paint. I said one day I might tell you wear your painting clothes tomorrow, and we'll try to paint that wall. But I'm scared. It's such a dark. It's not navy blue, but it's very dark, and I don't know. I may have to go buy some kills to cover it first, so that we
Oh,
can.
just a primer. Yeah.
Yeah, some kind of primer to cover. Because I'm not gonna put yellow right over it, because it might turn green. I don't
It
know.
probably
So
would. Make you a good green screen.
yeah, absolutely, absolutely. Well, I know Dean's been joining us every week, but I don't see him on here yet.
No, I just see Miss Michaela.
Mm-hmm. Anybody else? I don't know. Is Friday not a good day to do it, you think? Friday
Well, I
mornings?
don't know. Well, every other day is full of something else. So,
I know. There's stuff going on all the time, isn't there?
indeed.
Well, let's see if I can share the right screen here. I think I'm going to share this screen. Um, maybe. Let's see if I did it the right way.
I see it.
You see the form itself,
I
right?
do. Yes, ma'am.
Now do you see the like a
Stepping
PowerPoint?
through the tar.
Yeah. Yay. Okay. All right. Well, we'll start right there, and we'll just go ahead. And if folks want to come in, we'll be glad that they come in for sure. So we're going to talk about sections 13 and 15 today, and I truly can't remember exactly what sections we haven't talked about, but I may hit on some more of them. But this is the default paragraph, and we really need to understand it ourselves so that we can explain it to the buyers and sellers. I think that the buyer thinks that they can get their earnest money back for almost anything other than just walking away. I've actually heard agents say that. And that could be true depending upon what has happened. They could get their earnest money back. There's several places throughout the purchase and sale agreement that says if this happens this way, the buyer gets their earnest money back. So can they get a refund of their earnest money if certain things happen? Absolutely. But they also need to understand that their earnest money is forfeited, gone, first thing gone, if there's any kind of default. It actually says in this paragraph, should buyer default hereunder, the earnest money / trust money shall be forfeited as damages to seller and shall be applied as a credit against seller's damages. It goes on to say, seller may elect to sue in contract or tort for additional damages or specific performance of the agreement or both. And should seller default, buyer's earnest or trust money shall be refunded to the buyer. In addition, buyer may elect to sue in contract or tort for damages or specific performance of this agreement or both. In the event that any party hereto shall file suit for breach or enforcement of this agreement, including suits filed after closing, which are based on or related to the agreement, the prevailing party shall be entitled to recover all costs of such enforcement, including reasonable attorney's fees. In the event that any party exercises its right to terminate due to the default of the other pursuant to the terms of this agreement, the terminating party retains the right to pursue any and all legal rights and remedies against the defaulting party following terminations. The parties hereby agree that all remedies are fair and equitable, and neither party will assert the lack of mutuality of remedies, rights, and/or obligations as a defense in the event of a dispute. Now that paragraph is full of all kinds of legal language, okay? So we really have to understand what can happen. I might be able to say right now in today's market, a seller is not going to necessarily, probably not going to necessarily look at suing because they know the property is going to sell, okay? Unless something has gone on, right? But it doesn't mean they can't, okay? And the seller needs to understand it doesn't mean the buyer can't sue either. Now, the seller really doesn't lose anything, if you will, other than peace of mind that somebody's not going to sue them if they default on the contract. The buyer is the one that has to really worry, depending upon how much earnest money they put down. There are some areas of our state, Clarksville is one that I know of, up around the military base, and they don't always collect earnest money because the military folks supposedly don't have money, okay, to put as earnest money. I started teaching up there many years ago, and I've always told them, that's a scary place to be for a seller to take his house off the market and not have any earnest money. And in recent times, teaching forums up there, they're telling me they're starting to actually try to get more earnest money. So earnest money is not a requirement to have a contract in the state of Tennessee. So they don't have to. It's just a good idea. Makes everybody feel all warm and fuzzy all over. So let's look at a couple of these terms, okay? First of all, what in the world does default actually mean? Okay? When we're talking about contract law, default means failing to live up to one's obligation. And I liked the sentence. You can read on through here. It talks about in contract law, which is what we're talking about, when one of the parties to a contract fails to fulfill his obligation in the contract, he's said to be in default, and that's what we call it in our contract. But that very last statement right there, we're not really dealing with negligence, and they're comparing negligence and default. But I liked what it says. Defaulting is the intentional refusal to fulfill the terms of the agreement. And that's actually what default is. you're not doing what you have said you're going to do, okay? And in previous classes, we've talked about good faith, and that good faith is the foundation for basically all contracts. So you're going under contract in good faith, and then you're intentionally refusing to go through with it. That's what default is. So if we look at another term there, or a couple of ones, it says that somebody can sue in contract, okay? The buyer can sue in contract, or the seller can sue in contract. So when a contract is in breach, if you will, that's one party's failure to fulfill the contractual obligations. They're in default, and that's what it means to sue in contract. They've breached the contract. So somebody's going to sue because of the contract. To sue in torts, torts are civil wrongs that cause someone to suffer loss or harm, and in most tort lawsuits, if they sue in tort or add that to their suit, they're going to be seeking damages for negligence. Okay, and then specific performance is basically exactly what it sounds like. Okay, it is that the party is going to sue for them to actually perform the contract. Okay, they're not looking for damage awards. They want the contract performed. So that's what all that means, that sentence, that they can sue in contract or tort or for specific performance. So that's where that is. And it's real interesting that, people don't always understand these things. People think, well, who's going to sue me over a house? Well, it happens all the time. Okay,
Susan,
maybe not. Uh-huh.
Michaela has put in the chat, it says,
Okay.
but if you unintentionally miss deadlines, you're also in default.
Uh, if you that is true. That is true.
Right.
And that the words intentionally back over here under the default, if I can make it work. Um, if you unintentionally miss deadlines. So let's talk about that for a second. So unintentionally, what would be something that would be an unintentional missing of deadlines if you know what the deadlines are? What would make it what would make it unintentional if you missed a deadline? Now, due to
Are
the
you
pandemic,
asking us?
yeah, that's what I'm asking you.
Oh,
What what would that be? What would something be that if you had a deadline coming up, how could you prove that it was um, unintentional? Okay,
she says,
let's say
let's say
there's
that there was, okay, go
an
ahead.
emergency and they just forgot. Okay, so let's talk about that for a second. So buying a house in most instances is the largest financial activity somebody might take in their lifetime. Okay. So, and I understand that there are emergencies, and we've been through COVID, right? So if somebody has COVID, that could be an unintentional missing of a deadline. But let's talk about our duty as a real estate licensee. So if we are working with or representing a buyer or a seller, and they have a deadline coming up, we should be communicating with them and know what's going on. So if there is an emergency, then we need to take care of that and do an amendment to the agreement and extend that deadline. Okay, it's extremely important that we as real estate licensees stay on top of all this stuff that's going on so that our customers and clients don't end up in default, maybe unintentionally. Okay. But let me also add there that it's not my duty to your client and you to remind you of your deadlines. Okay. That's not what you're supposed to do, right? Um, I'm not supposed to just stay on top of Jennifer and Jennifer, do you have this? Jennifer, do you have that? Jennifer, do you have this? Just for example, this week I've got a new construction that's going to close here right after the 1st of March, and he's adding some insulation under the floor, okay, which isn't code. He's just doing it to be nice. And it's been raining all week, so he can't transport. He doesn't have an enclosed trailer. He's got an open trailer, so he can't transport the insulation because you definitely don't want it to get wet to install it. So the other agent is driving me nuts about when we're going to get that installed. So Monday she asked when it was going to be installed, and I said as soon as it quits raining, he's hoping to get it done by the end of this weekend. Every day this week, she has emailed me the same question, and so um, I'm probably not going to do that. I'm going to ask you one time, and when you give me the answer, that's going to be the answer. If I'm representing a buyer or a seller and there's a deadline, I'm not going to contact you and say, "Hey, your deadline's here. Are you going to meet it or not?" That's your responsibility as the representative of the buyer or the seller to remind them to meet the deadlines. Now, it's not up to you to do it, right? But it's to remind them to meet the deadlines. And we also have that timeline form, RF708, the timeline form that you can take and utilize with your customer or client and give them their deadline dates. And hopefully, I mean, they need to be like keeping up with that, putting it in their phone, making sure they know what's going on. And if you know there's some kind of an emergency, you got to let everybody know. I mean, I'm going to be honest. I've had folks had strokes. I've had folks have heart attacks. I've had houses catch on fire. I've had tornado affected houses. I mean, I've had trees fall. Things happen. And so that's when you get with the other agent and say, okay, here's what's going on. And we're going to want to extend this deadline. And I'm going to send you over an amendment. Okay? So, but it's not amended until everybody signs it. Remember that. And you have to send the amendment before the deadline passes. You can't send it afterwards. Okay? Are they mostly understanding? I'm going to say yes, specifically when it's a health issue. Specifically when it's a health issue. And if there's a tornado that's ripped through the community, yeah, they're going to be understanding. I mean, things are going to, especially if you're on the seller's side. If you've got a listing when the tornado rips through and it's affected, there's a lot of working together that has to happen. I've seen people, houses have been gone, okay, and the contract is just, null and void at that point because there's no house to sell. But I have seen some houses both damaged by fire and by tornadoes that they just worked together and they extended the closing date or whatever needed to be done until the insurance company, they could get the house fixed, and some of them have still closed. Okay, so yeah, that's the reason you just call each other and talk to each other. And I know I'll be honest, this agent emailing me every day, she's a newer agent, and I have corrected a couple of things, constructive type criticism, not tear her down or stuff like that, and she wants that. So one of the things I'm probably going to do today is email her and let her know he's supposed to try to go pick the insulation up since it's not raining right now, and at least get it under the carport, and try to start putting some in. And I'm going to let her know that, and I'm going to remind her that I told her this on Monday. And there's really not a need to email every day to ask the same question, because it just kind of ticks you off, because it's like, I told you that on Monday, and you're asking me every day. Basically, it looks like she's copying and pasting the same question every day. So
That's what I started to say. It sounds like inexperience.
it is. That's what it is. And it's the same thing if you're working with your lenders and your title companies. Don't drive them crazy every day. They can't get the work done if you drive them crazy every day. There's nothing wrong with shooting them an email and saying, "Hey, I'm just checking in this week. Let me know if there's anything I need to do." Okay? And if there's something, they'll let you know. They definitely will let you know that there's something. So, but it is important as the real estate licensee, whether you have a buyer's representation agreement or not, to keep that buyer on track, because we're all wanting the same conclusion. We're wanting to get to closing, and that's what we need to do. But But I'm going to tell you, if they miss their home inspection time frame, they just miss it. Most sellers are not going to turn around after it's done, after the time frame and say, well, it's okay, go ahead and go inspect. If you do, then you've got a really great seller to work with. But most sellers in this market are not going to do that. And I have to be honest here. It's mostly the buyers that are defaulting. Most sellers don't default. Now, I have seen it happen. I mean, I'm not going to tell you it doesn't happen. They just go, we changed our mind. We don't want to sell our house. It would be great if they do that before you ever list it, right? Which is that I had that happen yesterday, as a matter of fact. But it's mostly buyers. So the buyers agents, you got to stay on top of this stuff. Got to stay on top of this stuff because this was a question I answered this week. I got lots of friends up at Great Smoky Mountains, and one of the brokers up there said, okay, what happens when they don't close when they're supposed to close? I said, well, they're in default. What does the default paragraph say? They forfeit their earnest money. She said, even $18,000? I said, yes, even 18,000. It doesn't matter what it is. It says in the purchase and sale agreement if you default. And if you say we're going to close by this date and you don't close and the seller doesn't sign an extension, then you're in default. It don't matter if it's the buyer's fault or the lender's fault. It doesn't matter. You're in default. That's why, honestly, right now, the craziness that's going on right now, and it doesn't help you with the negotiating when you're up against multiple offers. But 45-day closings is something we really need to look at and start negotiating those in because appraisers are behind, home inspectors are behind. Everybody is behind. And when you're under contract, that seller may have accepted your offer because of the closing date you put in there, because they needed it to be then. And they don't have to sign any amendment to anything. Extending days, extending closing, none of that. They don't have to sign that. They accepted the offer or counter offered it, and somebody accepted it that way. Okay? So just remember that's extremely important that we stay on top of stuff. Well, let's move on in. It is breaking up. All I heard. Is it breaking up again today, Jennifer, or is it better with?
I think it's hers because mine isn't.
Okay. Okay. I'm very sorry, Michaela. There will be a recording of this when this is over that you can watch again also. If it keeps breaking up, just know that there will be a recording that you can watch. And hopefully it's clear. And that's where we definitely could tell if something's wrong. But I think if Jennifer's hearing me, then it must be coming across clear. Thank you, Michaela. So next we're going to move into, I believe, Section 15. Section 15 is one of the most ignored, if you will, sections of the purchase and sale agreement, and you really need to read through it so you understand what's going on here. So Section 15, I call it all the legalese, if you will, and there's, I don't even know how many subsections of 15, a bunch of them, okay? So it says that this agreement shall be for the benefit of and be binding upon the parties hereto, their heirs, successors, legal representatives, and assigns. So a purchase and sale agreement, if somebody passes away while they're under a purchase and sale agreement to purchase a house, it doesn't relieve them from purchasing the house like a listing agreement. A listing agreement becomes null and void when the seller passes away, okay? But a purchase and sale agreement, as you can see here, actually passes on and is binding upon their heirs. So when you have somebody in a purchase and sale agreement that passes away, then you've got to, the seller and the buyer they're both still under contract. It don't matter which side somebody passes away on, right? So the contract is still there. So folks may get together then and come up with a way to terminate the agreement. I have seen then the wife was left as the only buyer, and she didn't qualify for the loan by herself. So the she got a loan denial letter from the lender. So that worked out well for her. Okay. Um, so anyway, you got to understand the legal ramifications of this, but please don't tell people that. All right. Don't say, oh, well, you're still bound. Tell them they need to get with an attorney. That's the big deal. Okay. Because there could be some kind of caveat in the way they are purchasing, or if it's sellers and the actual way they have title on the property. So it just is telling an attorney when they read this that this can be binding, and it is assignable. The contract is assignable. Okay, so you have to understand that all contracts in the state of Tennessee are assignable unless the contract says they're not. All right, but this one is. And this agreement constitutes the sole and entire agreement between the parties hereto, and no modification of this agreement shall be binding and assigned by all parties or assigns to the agreement. No representation, promise, or inducement not included in this agreement shall be binding upon any party hereto. And this is the important part right here. Well, it's all important, but people really need to pay attention to this. It is hereby agreed by both buyer and seller that any real estate agent working with or representing either party shall not have the authority to bind the buyer, seller, or any assignee to any contractual agreement unless specifically authorized in writing within this agreement. So I'm going to stop right there. So there was this untruth going around, still is, that the real estate agent has to bind the agreement. And that is not true. Okay? It plainly says right here that real estate agents don't have the authority to bind the agreement. All right? So what we're signing when we sign on that acceptance is that we've been notified that a party has accepted the contract and there's now a contract in place. Okay? When the buyer or seller checks a box and says accepts and signs it, they're under contract. Okay? You do have to communicate the fact that an acceptance has happened to everybody to make it legal, I guess. And that's kind of a scary way to put that, but you can't sign that you accept somebody's contract and never let them know. Okay? So it's legal, and be very careful how you talk to folks about this because an attorney should be the one explaining that. So as a real estate licensee, we're only signing that we've been notified that there was an acceptance. Okay? You're not the one that binds the buyer and the seller. And so that changed 3 or 4 years ago because that's when the forms committee started hearing that there were instructors out there actually teaching, because it was called binding agreement date, and we were, agents were usually the ones signing it. So instructors were teaching that the agent has to bind the contract. The agent doesn't bind the contract. The agent acknowledges receipt that the contract's been accepted. Okay, that's what happens, and so we had to change that around. Then it goes on. I'm going to skip over a little bit on line 415 to where it says the parties hereby authorize either licensee to insert the time and date of receipt of the notice of acceptance of the final offer. That's been in there also forever. The forms committee hasn't changed this paragraph in more than 10 years until about 3 or 4 years ago, when we had to add the very last sentence that's in this paragraph that says the foregoing time and date will be referred to for convenience as the binding agreement date for purposes of establishing performance deadlines. Okay? We added that sentence. Otherwise, it was the same. There was another sentence there, and we wordsmithed it, I guess. But it just pains me to hear real estate licensees say to somebody, well, you're not under contract yet because I haven't bound it. That's not a true statement. And that could come back to bite you, okay? So the truth is, if Jennifer and I have a contract going on, and let's say her seller accepts my buyer's offer or my buyer's counteroffer, if she is texting me or calling me to tell me that they've accepted it, I may say to her, Jennifer, go ahead and fill in that acceptance date and send it on over. Okay? I might say that because I'm fine with that because the day I get that, that's day zero. My days for all the parties start tomorrow. Okay? And that's what it says on down in this paragraph. But I'm fine if she does that. Or better yet, when you are sending something, I mean, you usually have talked to your buyer or seller, and they know that, or you know that they're going to accept the offer, right? So you're sticking it in dot loop or transact, whatever you're using, and you've put the box there for them to check, accept, and sign. Well, do a signing in order instead of just letting everybody sign at once, and go ahead and add the agent's signature on there. Well, in dot loop, you wouldn't share it with the agent right then. You would share it after your party signs, but you can do that and just send it to them. And as soon as they get it, all they got to do is click on it and it's signed and it's done. Okay? Put them down in the acknowledgement of receipt. Put that other agent's signature there and do it that way. It just saves so much time and everybody can just move on forward with everything. Because that's what, again, that's what we're trying to do is we're trying to get to closing. Okay? So let's not hold that up. Okay? Make sure we don't hold that up. Any questions on that section? I don't see.
If that section is actually skipped over and say it's forgotten and where it's, it's supposed to be bound or whatever, is everything is still legal and legit?
The acknowledgement,
Yes.
um, that's definitely it. It could be argued that it's not. Okay, so that's a reason somebody's got to say, okay, you did inform me that your buyer or your seller has accepted this contract. Somebody's got to acknowledge that it happened. Okay, now what
Okay.
I've seen happen in the past is it's sent via email and then nobody signs it, and they go back and they get the date and time off of the email and add it later. Okay, so that it's that way. And another thing you need to know is that when you are signing that acknowledgement of receipt, let's say I write an offer for a buyer and we send it over to Jennifer's seller and Jennifer, and I just totally forgot what I was going to say because I looked out the window and saw something going on. Oh, okay. So, and let's say seller, Jennifer's seller counter offers, right? And my buyer goes, okay, I'll take that. And they're signing that. You will acknowledge receipt on the counter offer. You don't ever go back and put it on the original offer. The only time it's on the original offer is if the seller accepts it, as written. You don't go back and put it there. You sign acceptance on the counter offer. Okay, let's take a look at the next couple of sections. I put three of them together. The survival clause, it says any provision contained herein which by its nature and effect is required to be performed after closing shall survive the closing and delivery of the deed and shall remain binding upon the parties to this agreement and shall be fully enforceable thereafter. Think of the final inspection. Okay, if you find something like there was a broken window, I closed the house yesterday and we went for the final inspection, somebody had thrown a rock through the window. So we put that on the final inspection so it survives the closing. Governing law, it's written in Tennessee, then it is taken to court in Tennessee. And time is of the essence in this agreement. I'll let you know, not all contract forms has time is of the essence in this agreement. But because there are deadlines to meet, it has to be in this agreement. So time is of the essence means that everybody needs to complete everything by the date and time they say to, because if you don't, it causes breach of contract. Is what it is. Okay, so each party has, as it says here, contractual obligations to the other party. So they have to complete something so the other party can complete what they need to complete. So there's two or three definitions that actually float around out there about time is of the essence. So it basically it's get your junk done in the time frame you're supposed to get it done in. That's what it means. All right, next on that list is terminology, and I on purpose put it by itself because this is where it tells us how to count days, and people disagree about how to count days. The first thing I want to say about counting days is Do not change any section of any form to business days, okay? Because all these forms are made to work together on calendar days. Because if you change one form and then you forget to change it on another form, you got a big problem. Plus, if you change it, then you're practicing law because you don't know the ramifications it's going to have on everything else. So don't change to business days. So in this section called terminology, numbers 1, 2, and 3, those are basic contract definitions, okay? Singular shall mean the plural, and pronouns shall mean the person, entity, firm, or corporation. The masculine shall mean the feminine, and vice versa. So in case you say his or her or they or whatever, it's talking about everybody that's part of the contract, basically. Then we get to number 4, where the term days is defined. And they're calendar days ending at 11:59 p.m. local time. And that really can pertain to us here on the east side of the state, kinda, because you go on the other side of Dayton Mountain, you're in Central Time. You drive around 24, you get into Central Time. So we're really the only section of the state that has to deal with that. And the time is determined by the location of the property. So wherever the property is how you count the time. Then is the important sentence that you need to learn. So in bold it says, in the event a performance deadline, and then there's 2 very important words, other than. So that means that any performance deadline in the purchase and sale agreement, in your amendments, whatever you might have a performance deadline on, if it's any performance deadline other than the ones that are listed right here, okay, and the ones listed are the closing date, the date of possession, the completion of repair deadline, and the offer expiration date, or we call it the time limit of the offer. If those 4 occur on a Saturday, Sunday, or legal holiday, they drop dead on that day. It's done. But any other performance deadline, so let's think about what we've got. We've got the loan obligations paragraph, we've got a 3-day thing and a 14-day thing. If one of those falls on a Saturday, Sunday, or legal holiday, it extends to the next following business day, because that's what the form says, okay? If it is the 5-day pre-printed time frame in the no financial obligations paragraph, if it falls on a Saturday, Sunday, or legal holiday, it moves, okay? The 3-day thing in the appraisal paragraph, that moves. The home inspection days, however many you put in there, and the resolution days, however many you put in there, that moves, okay? Those are all moving targets. If any of those things fall on a Saturday, Sunday, or legal holiday, it extends to the next business day. So if it's any performance deadline other than the ones that are listed right here. Now, when you're counting days, you still count Saturdays, Sundays, and legal holidays, okay? If I had something that went under contract today, okay, today's the 25th, so today is day 0. Anytime you get notification of something as far as a performance activity goes, and you got to count days, the day you get it, okay, all the way up to 11:59 p.m. that night, that's day 0. It says in this last sentence on this paragraph, in calculating any time period under this agreement, the commencement shall be the day following the initial date. So today's day 0, Saturday's day 1, Sunday is day 2, and Monday is day 3. So by 11:59 p.m. on Monday, unless Monday's a holiday, we just had a holiday this past week, right? So if Monday's a holiday, it would bump to Tuesday. So that's 3 days. So by 11:59 p.m. on Monday, I'm going to have to send over the notification form saying my buyer has made application for the loan. All right, I got to count Saturday and Sunday. So if I had gotten this last Friday, Friday would have been day 0, Saturday is day 1, Sunday is day 2, Monday is day 3, but Monday was a legal holiday. It is President's Day, right? And so it would have been Tuesday by 11:59 p.m. that I had to send over the 3-day thing or whatever is due. So I Googled 5 USC 6103, which are federal holidays, and here they are. New Year's Day, birthday Martin Luther King Jr., which is the third Monday in February, Washington's birthday, President's, or January, third Monday in February, that's what we just had, President's Day, Memorial Day, Juneteenth, National Independence Day, June 19th. Let me count these. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Yeah. June 19th, July 4th, Labor Day, Columbus Day, Veterans Day, Thanksgiving Day, and Christmas Day. Those are the the federal legal holidays. So that's what we have to watch out for. When you're writing up your offer, if you're putting a closing date and or a time limit of an offer or something like that, time limit of the offer can be on a Saturday, Sunday, or holiday. It can be any time because it dies when it dies. So can a closing date, but you need to look very closely at a calendar when you are putting in your closing date to make sure it is not on a Saturday, Sunday, or a legal holiday. And let's, talk for a minute. When we're working through, let's say, Thanksgiving and New Year's, you got to remember that lots of people take off work. So when you're doing contracts between those days, you're going to have to understand it's going to be extended. So you might as well go ahead and put out the closing date a little bit because people take time off. Any questions on that section? All right. Next, we have the responsibility to cooperate. This is something that you really do need to read to them, okay, because they agree to take timely actions and produce, execute, or deliver information and documentation as is necessary to carry out the responsibilities and obligations of this agreement, okay? And they even say that if there's clerical errors, they will help fix them, okay? And if even after closing, they'll correct any documents and pay amounts due where such corrections or payments are appropriate by reason, mistake, clerical errors, or omissions, or the result of erroneous information. And I'm going to tell you what falls into that all the time. That, line 36, the fuel, line 36, because I wrote a $300 something check to somebody because the title company forgot to take it out because the seller's agent didn't get from the seller the amount of money they needed to take and send it to the title company when it was time to close. And it was a mess, and they thought we were ripping them off. Me and my buyers were just trying to rip them off, and on purpose didn't let everybody know it wasn't on the Alta. No, we didn't. We just didn't notice. We absolutely didn't notice because the seller and his agent didn't do what he was supposed to do. So I just wrote the check so everybody would be happy. I just paid the seller for the propane that was in his tank. And to beat it all, he had the darn invoice. He had it. They just didn't turn it in. So, make sure that you're on top of stuff, but it can come back to you after closing. Notices, this is extremely important. There's only 5 ways to deliver notice, and this notice paragraph is set up the way it is due to the statute of frauds that we have in the state of Tennessee that says everything we do in real estate will be in writing. And so in order to deliver notice, it's got to be in writing, okay, and delivered only by one of these 5 ways: in person, by prepaid overnight delivery service, by fax, by post office, postage prepaid, registered or certified return receipt requested, or email. I would like to say that every offer I get is via email these days. Okay, I can't even remember the last time somebody brought me an offer, okay, in person. They're all emails. And then it goes on to say here in capital bold letters, notice, because we wanted to bring this to your attention, shall be deemed to have been given as of the date and time it's actually received, okay? A receipt of notice by the real estate licensee or their broker assisting a party as a client or customer shall be deemed to be notice to that party for all purposes under this agreement, as may be amended unless otherwise provided in writing. Since we get and do email so much, and we have for years, and those 5 things of notice in that paragraph haven't changed, I don't think, since this document came out the first time in the year 2000. I think it's been the same way. Um, at least the first four lines of it have. So because everything is done by email, if I send an email, the courts will go by the date and time in my email, whether you open it for 3 or 4 days or not. Okay? So you need to understand you've got to stay on top of your email. Okay? You've got to stay on top of your email. And the best thing to do if somebody emails you an offer is reply back and say received. Okay? I mean, that is the best practice. Let them know in writing that it's been received. Okay? And sometimes, if it's a multiple offer situation, if I get it, I will email and say received and already forwarded to seller, something like that, so that I can prove that I've already sent it to the seller. Okay? And so, especially in multiple offer situations. Any questions about that one? I feel like my head's falling off. Now, everybody likes to text. We all text each other. And I'm not telling you you can't text. I'm just telling you there are certain things you shouldn't text. Okay? I'm going to show you this, and I may have shown you this before in other forms classes, because this right here makes me an absolute nervous wreck. I'm just going to tell you. This is an actual subpoena that I actually took service of in an office a couple of years ago. We had been expecting it, but we didn't know what all they were going to ask for. And if you look at this subpoena, they want everything, including your text messages. And when they talk about other communications, they also want your voicemails. I mean, and people are consistently cleaning up their voicemails and deleting text messages. And I'm going to tell you, you probably don't need to be doing that if it's between you and another realtor about property, or you and a buyer, or you and a seller, or whatever. You need to put those somewhere, because they're going to want them if it goes to court. So protect yourself and keep up with that stuff, okay? Next up, we are talking about risk of loss, equal housing, and severability. So we talked earlier about the fact that if there's a tornado or a fire or something, then there's going to be a hazard or casualty loss concerning in the damage to the property. Well, the seller bears all of that until title transfers, until closing, okay? So if something happens to that property prior to closing and it exceeds 10% of the purchase price, the seller or the buyer, either one of them, can elect to terminate the agreement, and the buyer gets their earnest money back, okay? So I'm sorry if you're hearing all that. I don't know if you can. I'm having issues. And I've had it happen, and then I've also had where there's a kitchen fire and the kitchen's damaged, and it might be 15% of the purchase price, but I actually told my buyer, the seller's going to have it all redone. I mean, you're going to have new stuff. And sometimes they hang on, sometimes they don't want to. But if it is 10%, exceeds 10% of the purchase price, either party can terminate. Equal housing, have mercy under all heavens. One of these days, maybe I won't even have to talk about equal housing, because I feel that anybody deserves the right to live wherever they want to live at, with no discrimination involved, and we can't discriminate. As a matter of fact, we only have the federal items listed on this form, but if you're a realtor in Tennessee, okay, no, I'm sorry, they added Tennessee. I just remember we added Tennessee there on line 451. Creed is there, okay? Creed is an additional protected class under Tennessee law. But if we're a realtor, then we have two others, sexual orientation and gender identity, under the Code of Ethics. So you got to remember all that. The next section, J, is about severability. If something happens and somebody goes to court over the contract, and any portion or provision or paragraph of the agreement is held or adjudicated to be invalid or unenforceable for any reason, it's severed from the remaining portions of the agreement, and the remaining portions are unaffected and remain in full force and effect. Okay, so adjudicated means make a formal judgment or decision about a problem or disputed matter. So this is, again, this is the legalese in my mind section of the purchase and sale agreement. And so this is a legal language that has to be in the contract, in contracts that we use. Next are three more that L drives me insane. I'm just wanting you to know it drives me crazy. But alternative dispute resolution, the forms committee, all the attorneys there's 3 attorneys on the forms committee every year, and the Tennessee Realtor legal advisors understand that the purchase and sale agreement only has one way to be resolved when people are arguing over stuff in it, and that's for it to go to court. Okay? However, we do have what we call our alternative dispute resolution capabilities, if everybody will agree to do that. But both parties have to agree to do it, and we have a form, the RF 629, and I'm going to show it to you in just a second, that they would have to sign saying they would do this. Okay? And sometimes it's hard to get them to do anything once they're mad and everybody's upset and all that stuff. But we do have a way of doing this, of going through mediation instead of going straight to court. Okay? Then L, contract construction, that right there makes no sense to me whatsoever. I've asked them to explain it. They've explained it 3 or 4 times, and I'm like, well, that still don't make any sense. Then I went and I tried to find something that I could help explain it to you. And basically what that is saying is that neither party can file suit against the drafter of this contract, okay, and use ambiguity or uncertainty as reasons for filing suit. So there's no construction against the drafter. Pure legal stuff. And if you don't understand it, it's hard to explain. Okay? And I basically tell my clients, this means that 2 lines means you got to hire an attorney if you got any questions, because they're the ones going to have to explain that to you. Okay? Section headings, they're for reference only. That's just kind of a normal in a contract kind of thing. So here is that resolution form, that mediation form. And in this form, it says that they're both going to agree to use what's called a Rule 31 mediator. Okay? So a Rule 31 mediator is an attorney that's also trained in mediation, which they are. But I could go get trained to be a Rule 31 mediator, okay? And so it tells you in this form where to go find a Rule 31 mediator, okay? And I just went and I found, there's only 3 in Athens, okay? There's 3 in Athens. There's more than this in Cleveland, and there were pages of them in Chattanooga. So it's not like you can't find somebody to do this if you're wanting to do this. It is less costly than hiring an attorney, because hiring an attorney, you're usually paying by the hour, or they've got some kind of flat fee, or it's going to cost you lots of money to hire an attorney and go to court. Okay, so if there's a dispute, then they can go through mediation. Now, another thing they may have to do is go through interpleader for earnest money. That's a different thing altogether. We talked about that in the earnest money paragraph. So interpleader is something altogether different. Have I lost everybody?
Did you do anything to the internet? Yes.
Okay. I'm still up.
Susan.
You guys see me? Can you see me? I can see you, Jennifer. I just feel blurry.
Oh, I can see you. I just heard nothing you said about this at all.
Okay. Oh, I'll go over it again. How about that?
Sounds good. Sounds good.
So this is a resolution of disputes by mediation, addendum, and amendment. The reason when something says amendment/addendum or addendum/amendment, then that means you can send it over with your offer, or you can use it as an amendment after you're under contract, because addendums are before you're under contract, amendments are afterwards. But this form, if they'll sign it, is where they will use what's called a Rule 31 mediator. okay? And that's somebody that's trained in mediation. Most of the time, it's an attorney, but, well, I shouldn't say most of the time. A lot of the times it's an attorney, but sometimes it's people that are just trained as a Rule 31 mediator. I could go get trained as a Rule 31 mediator, okay? So I went and looked in Athens. These are the ones in Athens. There's only 3 in Athens. There's several in Cleveland. I just grabbed some of them, and there's way too many in Chattanooga to even put up on here. But this is something that the buyer and seller can agree to do, okay, at any point in time in the contract, okay? It would be really great if we sent it over every time to say we're going to mediate first. I mean, if you can't come to a resolution through mediation, you can always go to court. But mediation is cheaper, okay? It's a lot cheaper than than actually going to court. It costs a whole lot of money. Now, this is not what you use if they want to interplead their earnest money. This is not that. I know when we did the earnest money paragraph, we talked about interpleader, but that's not what this is for. There's a different process for interpleading earnest money in a different form. But this is the form because everybody knows the 3 attorneys on the forms committee and TAR legal counsel knows that the only way to get resolution of the purchase and sale agreement and its peripheral forms all as the contract is to go to court, unless everybody will agree to go to mediation. So we developed this mediation form so that that could happen. Okay, so that's 13 and 15. We're coming to the end. I think this is the end of the purchase and sale agreement of what we're going to go over in the purchase and sale agreement, because I believe in March we're going to start going over some other individual forms. So if anybody has any questions or has a form they specifically want to go over, make sure and let me know, and we will make that happen because we want you to know what you're doing. Okay? Anybody have any questions?
No, ma'am, you've done an excellent job as always.
Well, thank you. And I actually got done with a few minutes to spare. All right. Well, you guys have a wonderful the rest of your day and a wonderful weekend, and go sell some real estate. Okay?
You as well.
See you later.
Bye.
Bye.